I'm going to talk about equality of beard, I don't think I can really match that one. I'm already lost on this. Ben, could you help me? I have it. Yeah. In fact, I'm very grateful to Gregor for his kind words earlier on out there. It's been a great privilege, actually, having been in the sort of international wilderness for a couple of years, to have been invited back into the fold almost a year ago, and it's been a great privilege to work with Stephen, and particularly with Toby. We spent a great deal of time together over the last year, travelling quite a lot. There's perhaps one thing that I would take issue with Gregor's description of Toby, that's the word courage. Having been on several long-haul flights with very modern air turbulence, or indeed in the lift of the Empire State Building on one occasion, I'm not sure that's the word that I would use, but there we are. Now, the International Criminal Court enforcement procedures. It is actually, believe me, it's a lot more interesting than it sounds. And for the next 45 minutes, I hope that I'll be able to convince you of that. This, as you know, is an institution which is really still in its very early days. And there's still a great deal of confusion about where it's going to end up. Before the adoption and entry into force of the Rome Statute of 1998, it was unclear as to whether and to what extent a duty to prosecute international crimes existed in international law. I'm talking about breaches of the Geneva Convention or the Genocide Convention, things like that. Under the Rome Statute, the ICC's jurisdiction is deemed to be complementary to, I think you might have heard of this earlier on from Stephen, rather than superior to that of the national justice systems whose effectiveness are not to be undermined by that court. And it's limited in its ambit. It's limited to the most serious crimes of concern to the international community as a whole, and those core crimes enshrined within Article 5 are typically genocide, crimes against humanity, war crimes and aggression, which we haven't heard much about yet. The idea behind the court was independence. It is independent, it's permanent. The idea was to avoid this notion of victim justice, which is an epithet that's been thrown at various of the ad hoc tribunals with some justification, in fact, over the last 20 years. The theme line behind this lecture is however much or however hard you try to ensure an institution is independent, politics at the end of the day always gets in the way. So the purpose of this lecture is to start really by trying to describe to you where the jurisdiction of the ICC lies. I don't want to spend too much time or detail on that. More so I want to talk about the efforts, or rather the methods that can be used to apply to enforce that jurisdiction. And with some recent examples to show just how problematic and how difficult that is proving to be. So we're going to go to Sudan, the Darfur situation, briefly to Uganda, and then finally we're going to deal with the issue of bilateral agreements, which really are proving very obstructive to the smooth running of the court's jurisdiction. The court's jurisdiction really commences from the 1st of July 2002. You can't have retroactive jurisdiction extending back before that. The preconditions that must be in place in order for a prosecution to be brought are that the country concerned has to be a state party, this is Article 12, and the crime alleged has to have taken place on the territory of a state party, or the crime has to have been committed by a national of a state party, doesn't matter where that crime was committed. or both. So crime on the territory of a state party, crime committed by a national of a state party. In fact, none of the initial prosecutions at the ICC seem to have been based on the nationality of the accused. Potential for that arose with British soldiers in Iraq, where the prosecutor's report of 2006 indicated that because inquiries had been made in this country of our service personnel committing crimes in Iraq after the invasion, that essentially negated the need for the ICC to intervene or entertain any sort of complaint or investigation. But thus far, no prosecutions have got off the ground at the ICC on the basis of a perpetrator's nationality. Now, there is an alternative way in which jurisdiction may lie, and that is within Article 12.3. This is a curious little sort of opt-in provision which allows non-party states to effectively opt into the ICC jurisdiction with respect to the crime in question, in inverted commas. That is a provision which attracted a great deal of dissent from the Americans, surprise, surprise. They argued that, for example, it would allow the Iraqis to invoke ICC jurisdiction for crimes committed by American servicemen in Iraq, whilst at the same time authorising the court to do, without at the same time authorising the court to do the same in relation to atrocities committed by Saddam's own henchmen against the Iraqi people themselves. That was their objection, but it's there, Article 12.3. You can opt in to the crime in question if you wish, without being state party. So how is the jurisdiction triggered? Well, I'm not quite sure how far Stephen went into this earlier on, but I'm going to run through this very quickly. There's Article 13A, which is the situation in which one or more of the Article 5 crimes, genocide, crimes against humanity, etc., appear to have been committed, and that situation is then referred by a state's party to the prosecutor to investigate. This covers the examples of where a country would refer itself. Between 2003 and 2004, Uganda, DR Congo, Central African Republic, all referred themselves under Article 13A. In actual fact, they were lent on a little by the prosecutor, who sort of threatened them with 13C, procreo motu intervention, but saving themselves the embarrassment, those three countries applied under Article 13A and essentially referred themselves. Now, self-referral typically, and it was with this in mind really, it typically refers to the situation where a state is unable to proceed owing to, say, a breakdown in its own national justice system, or a pre-existing legal impediment such as an amnesty. Now, you might think that using the ICC's jurisdiction to supervene a legal amnesty that's already in place is playing a bit dirty. I've got some experience of that in Sierra Leone. It wasn't an ICC jurisdiction case, but there was an amnesty in place there, and that was overridden by the court, which was set up as a result of bilateral agreement between the Sierra Leone government and the Security Council. And the amnesty, which effectively allowed carte blanche to a myriad of rather shameful individuals, was basically driven over roughshod. Not the most elegant way to start an international tribunal. And it's a little disturbing, perhaps, to see that that capacity is still there. Article 13B covers the situation in which, and this is where we start getting into the politics, it covers the situation in which one or more of such crimes appear to have been committed and is then referred to the prosecutor by the Security Council, acting under Chapter 7 of the UN Charter. Well, the conditions of the application of Chapter 7 are very simple. They refer to the existence of any threat to peace, breach of the peace, or an act of aggression. it's for the judges to decide whether the Security Council's referral complies with Chapter 7's requirements of the words I've just read out to you. It's a quantitative and very subjective analysis one might find. And it doesn't avoid the risk and the possibility that the Security Council, often driven by politics, we all know that, may wish to invoke jurisdiction by 13B because of some political motive. What 13B does is it confers power upon the ICC to exercise jurisdiction regardless of whether the country in question is a state party, provided it's got Security Council authorization. Now, to date, the only example of Security Council intervention in this way is the situation in Darfur, Sudan. Because Sudan is not a state party to the statute, and without authorization, the ICC couldn't exercise its jurisdiction there, unless it was a national state party on Sudanese territory. Well, many have argued that 13B effectively reduces the credibility and the moral authority of the ICC. It limits its autonomy and undermines its independence, potential for importing inappropriate political influence into the mechanism, as well indeed as perhaps conferring powers upon the Security Council that were never anticipated in the original UN Charter in any event. More controversial still, and I know Stephen was talking about this morning, 13C, that basically gives the power to the prosecutor of his own initiative to initiate an investigation in respect of one of the classified crimes. It gets off the ground by way of the pre-trial chamber being given information by the prosecutor, essentially to give a green light for prosecution. Of course, this attracts the obvious criticism. It's open to political motive. Whose information does the office of the prosecutor choose to use? Who supplies it? There's really no way of placing any scrutiny on that, and it's a troublesome provision. Kenya is the only example of that so far. There are examples of where the jurisdiction cannot apply, and they are covered by Article 17 of the statute. And I'll run over these quite quickly because I want to move on to Sudan and try and explain how this all works in action. Well, 17 states that a case is inadmissible, in other words, you can't bring it, where a case is already being investigated or prosecuted by a state which has jurisdiction over it. So it's upholding this principle of complementarity, giving the actual state itself the right and the initiative to handle its own problems. Unless that state is unwilling genuinely to carry out the investigation. In other words, it's pretending that it's really got an ulterior motive of trying to protect the suspect. That is likely to be what happened in Sudan. Or it is unable genuinely to carry out that investigation or prosecution. Collapse of the legal system, for example. Sierra Leone would have been a perfect example if it had fallen under ICC jurisdiction. Second area where a case could not be brought is where it's being investigated by the state that holds the jurisdiction, and they decided not to prosecute on a genuine basis, to put it shortly. Thirdly, where the person has already been tried, double jeopardy. And fourthly, where it's deemed that the case is of insufficient gravity to justify further action. I must emphasise, we're referring to those crimes of the most serious concern to the international community as a whole. A one-off murder, rape, something like that isn't going to qualify. Essentially, Article 17 then, the list of areas where a case is inadmissible, is a mechanism for ensuring that the court is complementary to those national jurisdictional systems. So then we come on to enforcement. And Yes, the cursor works. Sudan you see there in central western Africa. Under Chapter 9 of the Rome Statute, in particular under Article 36, there is a requirement on states parties that have ratified the treaty, all 119 of them, to cooperate fully with the court's investigation and prosecution. The situation in Darfur gives a perfect and contemporary example of how jurisdictional and enforcement issues work, or maybe don't. And it's a poignant example of how difficult it is for the ICC to actually carry out its objectives, particularly in the face of localised political allegiances, and I'm referring in particular to the countries surrounding Sudan. A bit of history then. The Sudan Liberation Army, the SLA, and the Justice and Equality Movement, the JEM, formed rebel movements. They began attacking government targets, notably El Fasher Airport in early 2003, accusing the government in Khartoum of oppressing black Africans in favour of Arabs. Now, Darfur, in the arid part of western Sudan here, has faced many years of tensions related to land and grazing rights between nomadic Arabs and farmers from the Fur, the Masalit and the Zakawa regions, which are, again, in the west. Well, the government has openly admitted mobilising self-defence militias in response to rebel attacks. But it's always denied that it's had any links to the Arab Janjaweed militia, who are accused of attempting to drive black Africans from large swathes of what was hitherto always, and for generations, have been their territory. Well, al-Bashir's public called the Janjaweed thieves and gangsters. But locals who report government air raids say that they're frequently and immediately followed by attacks from Janjaweed militia, who would ride into villages, clearly, and this is the point, clearly targeted on their ethnic composition, on horses and camels, and just lay the villages to waste, burning them down, murdering the men, raping the women, poisoning the wells, basically waiting outside villages for villagers to go out into the desert trying to, or going on food or water finding missions, and killing. Violence has spread into neighbouring Chad, border here, where thousands of Darfuris have fled. Now, the UN say that about 300,000 people have died, mostly from starvation and disease as a result of what's been happening to them, and 2.7 million have been displaced since the conflict started. To appease the United Nations, trials were announced in Khartoum as some of the security forces suspected of the abuses. But that was very quickly seen as a ruse, an example really of the government unwilling to take action against the individuals concerned. The thing was, though, that Sudan, as I've said, still isn't a state party to the Rome Statute. And as such, the ICC on the face of it had no jurisdiction to intervene. So the Security Council did, applying Article 13b, referring the situation in Darfur, as it was known, under Security Council Resolution 1593 in March of 2005. Office of the Prosecutor applied for arrest warrant for crimes against humanity and war crimes in March of 2009. Later, controversially, for genocide in July 2010. But today, in November 2011, President al-Bashir remains, quite literally, at large. And by at large, I mean at large. He's been freely allowed to travel around the neighbouring diaspora. Well, I seem to have lost my ability to move on to the next picture. Did you help me, Dan? Okay, thank you very much. Now, 5 issues arise out of the current situation whereby Bashir has been allowed to travel around the diaspora and talk about Chad, Central African Republic, this sort of area here. The first issue I want to talk about briefly is the obligation of the state party ratified the treaty to arrest Bashir outside Sudan. Sudan might not be a party to the ICC, but many of its neighbours are. As I said, Article 86 generates the general obligation to cooperate. That cooperation is guided by certain protocols in Article 87, and there is a special obligation on those countries, should Bashir enter their borders, to comply with the request for arrest and surrender or transfer him to The Hague. What if they don't comply though? Well, in actual fact, this is where the ICC really shows itself, and has done, to be rather toothless, because Article 87.7 provides that where a state party fails to comply with a request to cooperate, the court can make a finding to that effect and refer the matter to the Assembly of Parties or to the Security Council if it's a Security Council referring case. Well, what does that mean? Actually, not very much. Kenya and Chad. There's Chad, there's Kenya. This is the first little case study. In July of 2010, al-Bashir travelled to Chad. In August of 2010, he was invited by the government of Kenya to attend celebrations for the introduction of their new constitution. They didn't surrender him. The pre-trial chamber in the Darfuri case simply reported Chad in Kenya, invoking Article 87.7, without requesting them to offer up their comments or an explanation in response. Reported them to the Security Council and the ICC Assembly of Parties, and basically that's it. Encouraged, President Bashir then went to Djibouti. Djibouti's up here somewhere. There we are. In May of this year, at the inaugural ceremony of their president. He was getting confident now, and with all good reason, because they didn't try to arrest him either. The United Nations Security Council, equipped with overriding powers under the UN Charter, has done absolutely nothing in response. Gaining confidence, al-Bashir, in August of this year, so this is getting quite contemporary, goes to Chad again to attend the inauguration ceremony of the head of state, Idris Deby Itno. No arrest was made despite the ICC sending a note to the Chad embassy in Brussels asking them to comply. Once again, Chad asked to send a written explanation. I believe they did. It's confidential, but nothing else happened. More recently, Malawi. I'm not quite sure what he was doing there, but I think it was something to do with a common market for Eastern and Southern Africa trade delegation. 14th of October, just a month ago, he was in Malawi. Same thing happened. The Malawian embassy was sent a note by the ICC in Brussels in October, but they did nothing. On the 19th of October, the trial chamber again requested written observations from Malawi. I think they were filed on the 11th of this month. That's all. So you might get the impression that when it comes to Darfur and the 2.7 million people displaced, or 300,000 people who have died, the ICC has proved itself to be something to take the tiger. What about the obligations on non-state parties? Because Bashir hasn't just been to these countries, he's been further afield as well. He's been to China, to Eritrea, to Egypt, to Libya and Qatar. Well, once again, the ICC really can't, in real terms, do much about it. Article 87.5, and I quote, encourages non-state parties to cooperate generally, and in particular if the Security Council resolution is involved. 1593 resolution quotes, and I quote, says this, decides that the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully with and provide any necessary assistance to the court and the prosecutor pursuant to this resolution. And while recognising that states not party to the Rome Statute have no obligation under the statute, urges all states and concerned regional and other international organisations to cooperate fully. Doesn't sound terribly coercive, does it? And it's not. They have no power in reality at all to get non-state parties to cooperate, other than invite them to, as I just said. Thirdly, is there an obligation on Sudan? Well, no, there isn't. Sudan is not a states party. Although the resolution 1593 clearly binds Sudan and imposes full Rome Statute obligations on it, many competing arguments have been advanced, particularly amongst academics, and very sensibly too, as to whether this is a proper method of action, considering that Sudan always was and remains a non-party state. The fourth observation is really the realpolitik of this, the conflict of international obligations as against ICC obligations. Because when I talk about the countries in the diaspora that al-Bashir was visiting, it's notable that they're all members of the African Union. Well, it goes like this. In July of 2010, the AU made a decision not to abide by the ICC arrest warrant. A very bold move, because they have part of their own constitution, it's the Constitutive Act, Article 23 to be precise, which basically says if you all agree to do something within the African Union, you stand together, otherwise it's on pain of sanctions. Creates a conflict, of course, with those parties who are in the AU who are also state parties of the ICC. Is their allegiance to the ICC treaty, or is it to the AU constitution? Well, previously, when I'm going back to 2008, the AU had requested a 12-month deferral of al-Bashir's prosecution, which is something they can do under Article 16 of the Rome Statute. That was refused by a UN resolution in 2008. But the AU weren't to be deterred, and in 2009 they tried it on again. Again, it was refused. Now, this was, that request was ignored, and in actual fact, in July of this year, they tried a third time under Article 16 to get the Bashir arrest warrant deferred. Now, on this occasion, in Equatorial Guinea, this is where the conference was held, the AU Assembly of States reiterated its opposition to al-Bashir's prosecution. And they challenged the Security Council, as I said, to invoke Article 13 a third time, but very boldly demanded non-compliance throughout all the membership of the African Union with those arrest warrants. The AU reaffirmed that by receiving al-Bashir, Chad, Kenya and Djibouti were discharging their obligations under their own AU constitution. But they were also invoking Article 98 of the ICC constitution, they said, which expressly upholds immunity for heads of state of non-state parties, as well as claiming that they're acting in furtherance of the peace and stability of the region. Well, this, as I've indicated, leaves an impasse. States parties to the Rome Statute are obliged to cooperate with ICC in the enforcement of the al-Bashir arrest warrants, whilst decisions of the AU, which are binding on all AU members, demand the contrary. It may be that the only way through this is, sadly, once again, a political solution. The fifth observation on Sudan, the last one, is does al-Bashir have immunity? Well, Article 98 confirms that there are immunities for heads of states of non-state parties. The problem is, as I've said, that Article 1593, in deciding that Sudan will cooperate with the ICC in this investigation, has effectively elevated Sudan to the status of a state party. And to take that logical extension, if you move to Article 27 of the Rome Statute, you will note that state parties have or immunities to state parties, the heads of state of state parties do not apply. So much contradiction here as well. Some say that the ICC is counterproductive and harms the peace process. And Sudan proved the point, because days after the ICC indictment was laid, al-Bashir expelled no less than 13 international aid organisations from Darfur and disbanded its own. Conditions in the refugee camps deteriorated. Darfur rebels who were in the peace process with the Sudanese government declared that there was no longer any need to engage in that peace process, since the ICC had already labelled the Sudanese president as a criminal. So why sue for peace with him? Most of the important rebel groups refused to sign the peace agreement. The government allowed the Janjaweed to carry on brutalising them. Many have said that attempts to pursue these arrest warrants is going to do nothing more than promote or provoke further instability in the region. And the issue of peace process is highlighted by the situation in Uganda. This is Joseph Kony. Joseph Kony is a very interesting individual. He's the head of the Lord's Resistance Army in northern Uganda. It's a peculiar militant group that goes by a heady concoction of Christianity and traditional African black magic. In resistance to the democratically elected Ugandan government, they practice on a large scale murder, abduction, the mutilation of their victims, sexual enslavement of women. They use child soldiers, but they are apparently careful not to harm snakes or bees. Activities have spilled into the Congo and now into what is now known as South Sudan. The ICC took action against Kony after the Ugandan President Museveni, referred this matter in 2004. By accepting Museveni's invitation to investigate the LRA, announced in London rather foolishly, one might have thought, by the ICC Chief Prosecutor standing next to the President of the press conference, it appeared that the ICC had taken sides. So rather than being a promoter of peace, suddenly you appear to have the ICC as a protagonist in the war. There is a provision under Article 53 which allows a discretion not to prosecute where to do so would be contrary to the interests of justice. Well, that is exactly really what happened here. One could, I think, properly argue that prosecuting Uganda, or the LRA rather, was very much contrary to the interests of justice. Why is that? Well, NGO groups and representatives of civil society had actually approached the ICC directly to withdraw its indictment in order that an extremely popular amnesty solution could be pursued. Tempted many abducted children who were going to be pressed into service as child soldiers out of the bush, and it was proving very successful. The ICC indictment stopped all that. In advance of the peace talks, initially due to open in Juba in what is now South Sudan between the Ugandan government and the LRA, to discuss the ceasefire and the peace agreements mediated by South Sudan's Vice President. In July of 2006, Uganda's President Museveni declared that he would grant Kony an amnesty, provided he made peace and renounced terrorism. The problem was that there was a deal. If the LRA were required to send one of their top leaders to the conference, to the peace conference, but Kony refused to participate, no doubt fearing arrest and prosecution at the ICC. So peace talks failed, and with it did the amnesty program, and the future of the child combatants was once again thrown into doubt. I mentioned one final area where politics rears its ugly head, and that is the situation surrounding Article 98 of bilateral immunity agreements. There was supposed to be a map on here which showed America, and it hasn't turned up, so you just have to take my word for this. There's a map on Wikipedia which shows the world. There's the United States of America. There's the rest of the world. It is alarming when you look at this map and you see that America, not a state party to the ICC, having made bilateral agreements with so many countries, have turned great swathes of the world, particularly the third world, into a red colour. You can see it on the Wikipedia website. And the countries that are red are third world countries which have entered into bilateral immunity agreements with America, pursuant to Article 98. Now let me explain very quickly, so we're nearly finished, what that means. Essentially, in the past, there were bilateral agreements between various countries, notably the US and their friends, which allowed military activity, often by US troops, on those territories, on those countries' territory. They were often known as SOFAs, the Status of Forces Agreements. And the US had, obviously, a plan. They could see the ICC coming, and since the ICC has been created, they've continued to make these agreements. It's to ensure that their nationals are not prosecuted on the territory of other state parties. Article 98 governs those immunities, essentially making obligations of arrest and surrender under the Rome Statute subordinate to other legal norms. In other words, subordinate to pre-existing immunity agreements. It rather rides a coach and horses through the whole spirit of the treaty, because it enables certain powerful states to protect in advance the wrongdoing of their nationals on state party territory. It's been ripe and open for abuse, and it has been abused. Essentially, 98 provides that the ICC may not proceed with a request for surrender that would require the requested state to act inconsistently with its obligations under international law, or, more relevant for our purposes, its obligations under pre-existing international agreements, unless that requested state waives the immunity or grants cooperation. What happened was that after the statute was adopted, some very creative US lawyers relied upon Article 98 to devise strategies to limit the ICC's jurisdiction through this series of bilateral immunity agreements or non-surrender agreements. In other words, what they did was to create a network of connections with selected, largely third world countries in order to prevent the handover of its citizens if the ICC wanted to get hold of them. How do they ensure these agreements are signed? Well, that is simple and inevitable. They exert relentless political pressure, including threats to withhold military aid and economic aid and humanitarian aid, to effectively force those weaker states to sign those agreements. So what was intended, was rather than Article 98 be cynically used to enable these agreements and protections, it was simply designed to prevent legal conflicts that might arise because of pre-existing agreements for renewals of for example, the SOFAs, the Status of Forces agreements. What it wanted to do was not interfere with agreements that had been made before 1998, but it's been abused. What the bilateral immunity agreements have done is simply create a myriad of potential conflicts of obligations for those states that have to be resolved. Do they go the ICC route and respect the jurisdictional powers of the ICC, or do they uphold the bilateral agreements with that one state that they've made? Resolution is not an easy topic. And it will therefore be up to the ICC to decide whether or not the so-called Article 98 agreements proposed by the US are valid If they don't, how they're going to resolve it, it remains to be seen. Well, I hope that has given some sort of or some idea as to how the ICC is approaching these particular difficulties. I hope it's also given you some impression of how far the ICC yet has to travel in order to create a world free of conflicts and obligations, and a world which doesn't always kowtow to the power of a superpower. Thank you.